Welcome everyone to our industry update this month. We're glad to have you. Before we introduce our guest for the month, we just wanted to remind everybody of all of our future industry updates. We have them all planned for the whole year. I'm not going to go through this whole list, but make sure you've saved all these dates. So next month we'll have Marsha Waters on. That's always a really popular session. So we'll look forward to seeing you at future updates, and please invite your fellow brokers. The more, the merrier. We hope you're getting a lot out of these. And with that, I want to give a really big warm welcome to Merc Pittinos. He's a return guest. He had a super popular session with us last year. Merc is an amazing real estate litigator with a downtown law firm. So he gets to deal with buyers and sellers when they're really mad and get to the point that they start suing each other. And sometimes they like to drag their brokers into it as well. So that's the juicy meat that we're going to talk about in today's session. And he's going to give us some tips and ideas on how to try to keep ourselves and keep our buyers and sellers out of those situations as well. So thank you so much, Merc, for being on. Your time is so valuable, and we really appreciate you giving us your time and expertise today. So with that, we'll turn it over to you.
Thank you very much. Appreciate it. Thank you for having me talk. Just for context, the work that I do is all helping people resolve real estate disputes and litigation. And what I wanted to talk about today is what are the things that I see over and over again in real estate disputes, and hopefully give you guys a handful of tips that you can use to be able to avoid getting into litigation. And one of the reasons that this is easy to do is that the same problems pop up over and over again. And over the last year or so, the problems that are causing most disputes are pretty typical, and they're tied to market fluctuations. So over kind of through last year, where there was essentially just a feeding frenzy, anytime that there was a property up for sale, whether it was residential or commercial, there were things that were happening in deals where people were overlooking things that they normally they normally wouldn't have overlooked. And so it meant that there are properties that were sold without, sometimes without appraisals, sometimes without inspections. And probably the most frequent call that I receive is 30 days after a closing, someone calls up and says, "We've just bought this house," or "We just bought this property. We found a mold issue or a water damage issue or a sewer line issue, and it wasn't disclosed. And now it's going to cost $10,000, $20,000, $30,000, $40,000 to fix. Do I have a case?" That's the number one question over and over and over again. And most of the
sorry about that, Mark. It might be me that's sending those people your way. For those of you that don't know, Mark's one of the people that I refer out because he does such a great job for plaintiffs work. So if you have clients looking for an attorney, he does handle it well, and I like the way he tries to resolve things. But yeah, sorry about that, Mark. I didn't mean to send them all to you.
Thank you. But a lot of times there's really there's not anything that can be done, and there are a couple of different reasons why. One is that a lot of times that the cost of hiring an attorney is more than solving the problem. And when you take the cost of hiring an attorney and then you add the stress that adds to your life, a lot of times it's just better off to fix the problem and move on. The other reason is that in a lot of cases, people have they've waived inspection rights in order to facilitate a deal. And so when you do that, and you do it in the stress and in the flow of a transaction, when there are a lot of people competing for a property, you're giving up rights that later on you wish that you didn't. But that's the second reason that a lot of people recently have come and said, "We've got this problem, but there's not much that you can do about it." The third issue that I see a ton is just that when people fill out their disclosure forms, there's sometimes where they just outright lie, but in my experience, it's not that frequent. And so when you have a dispute and you reach out to a seller and say, there was this problem we discovered after the fact, we want you to help make it right. There's a small percentage, maybe 5 to 10% of the people that say, you're exactly right, I'm going to make it right, and they solve it. And then most people will say, you know what, I didn't know about it, or they come up with an excuse, and it really turns into a battle of two different people, he said, she said. And in that sort of situation, that type of lawsuit is incredibly expensive. It's really hard to win. And unless you have concrete evidence of somebody lying on their disclosures, they're not really great places to bring. They're good for lawyers, but they're not good for the clients because they're really expensive and it's hard to guarantee an outcome. And when I'm talking to clients and trying to help them understand whether it makes sense to engage a lawyer and to either bring a lawsuit or write a demand letter, the way that I look at it is that it's investment of time and money, and there should be pretty close to a guarantee of a return. So unless you can guarantee a return 5x, 10x, that's the sort of situation where I say to clients, this makes sense. This is worth your money if you can get a pretty big return. But if you're breaking even or losing money, it's not worth it. You should just move on.
And Merc, can I interrupt you just for a second? Because
Sure.
I love your advice because I think it's the right advice, but there's a lot of plaintiffs lawyers out there that will take cases like this and send demand letters and are happy to spend the client's money to try and win these cases. So I think that's important to point out, that just because that's your advice doesn't mean that's the same advice that the client's going to get from somebody else. But can you talk about what it is that the client should be looking for that is the guaranteed, or what kind of evidence would you want to see if you're going to take one of these cases?
So I think there are a couple of different examples. One case that where I worked with some clients a long time ago, there was water damage in the house that was discovered, and when we sent a demand letter, the people came back and said there's never been any water damage. We have no idea what you were talking about. And then because of the water damage, the person that bought the house pulled up the carpet where they had seen the water problems. And underneath the carpet, there were 2 different colors of carpet pad. And then there also was mold, and you could see where things had been repainted. So you look for things like that, like something unusual, like 2 different colors of carpet pad, recent painting, drywall work, that sort of thing. The other place where it's really good to find information is neighbors, because when people have something bad happen at their house, usually the first person that they tell are their neighbors. And so if you have an issue that comes up and you're talking to a neighbor, they'll usually tell you, oh yeah, I remember when the electrician was out here to work on that before, or when the plumber was out here, or when the drywall was repaired. And then I have no idea why this happens, but because people that do work, there's so many people that do work on houses, but I can't tell you the number of times where I've had a client who said, I hired this person to come do some repair work, and just by chance they said, oh, I've been out here working on this before. So it's really, and then the other really good place is that if it's work that should require a permit, you can go to the city or the county and look in permit records to be able to figure out what work has been done on the house on the house or building before. So those are the places that you can find that information and figure out whether somebody's experienced before. Where it gets tricky is that you may be able to find evidence that somebody did a repair before, but you can't tell whether it was them or it was the prior owner. And that's one of those reasons that those cases can be, they can get complicated. Were there, and in your experience, Damon, have there been other things that you've run across where people have been good tools for people to figure out what work's been done?
You've hit on the biggest ones. I agree with you. I don't know why, but for some reason, the buyer always calls the same contractor that the seller used. It's like clockwork every single time. And I mean, it's like in the middle of Denver, there's got to be hundreds of HVAC contractors, but for some reason, they always choose the one that the seller had. That's the one that I think has merit to it. I can't think of any other ways that they can get that information. I agree with you. It's tough to prove a case of he said, she said, and they're just going to say, well, I didn't know. And so unless you can prove that they knew, it's an uphill battle. So, I think that's good advice, because I think a lot of times the brokers get dragged and asked, well, do you think I have a claim against the seller? And I like to tell them, temper their expectations, because it may not be as good as it seems. It seems obvious that the seller knew, but proving it is another thing. So
Yeah, that's a whole different. The other place that we found helpful information is that when a house has been listed multiple times, and you can find old photographs online from prior listings, sometimes there's really good information there that you can use to put together a story to say, here's why what you're saying doesn't really make sense. And then there are times where people just flat out lie on their disclosures. And those ones are fairly easy. And that would be something like, we've never done any electrical work on this house. And then you go and you can just look at the panel and tell that it's not as old as the house. Or
the permit was pulled by them.
Yeah. Or there was no permit pulled, and there are wires all over the place that, that even a lawyer can tell wasn't done by an electrician.
Which is saying a lot.
That's exactly right. I think then there are a couple of we've had a couple of, so I think, and then the corollary to that is the best way to be able to protect your clients is to tell them over and over again to make sure that they disclose everything. And there is always a fear on the behalf of people selling their houses that if I write it down on the disclosure form, then it's going to cause a problem in the deal. And it's just natural it's people's psychology and how people are wired. And my guess is that, especially with as hot as our market is right now, it's probably never, sometimes it may interfere with the deal, but most of the time it doesn't. That what you end up, it's sort of like people that go to testify at Congress and they get in trouble not for what they did, but for when they lied to Congress. And that's sort of the same thing here, that you're probably not going to blow up a deal by what you write down, but if you try to cover something up or you forget about it intentionally, you're much more likely to get into trouble. And I think the kind of examples that we just talked about are why that for some reason the same contractor shows up. You can't control what your neighbors say. And so there's a pretty good record of bad things that happen because people talk about them. And so it's much better to be over-inclusive on disclosures. And to really
along those lines, Merc, there was a question that came in. Sorry, I don't mean to interrupt.
Okay.
That said, what a neighbor say be hearsay since they don't actually live in the property, or maybe the neighbor is lying, is the question. If you want to address that when the neighbor says, oh my gosh, yeah, there's this problem or that problem, and tells the broker.
So it is, if you were in court, what the person told the neighbor wouldn't be hearsay because there's an exception for the rules for that. So they would be able to come in and testify about it. But really where it's helpful is that when you're in, probably 95% of the time, this sort of dispute results in a settlement, and it doesn't really, so it's possible that the neighbor's lying, and if the neighbor's lying, the seller will tell you that. But what it really helps to do is it helps you to figure out, do I spend money on a lawyer, and is there a real problem? And then it gives you a tool to be able to go and say, we think you ought to settle because you knew about this beforehand.
No, that's good. Thank you.
Yeah. So one, the over disclosure, it is emphasized at in the continuing education classes you take. And I know that it's one of the things that brokers hear over and over and over again, but for me, it's almost the number one thing that I see in disputes, is that even on disclosure forms that are filled out pretty well, it's the places where people don't write anything that they end up getting into trouble. And I think that that's probably the number one advice, is that especially on things related to mold or water damage or roof issues, any kind of foundation cracking, it's much better to be over inclusive and just write something, because in those situations where if you have knowledge and you don't write anything, you've got issues. Another thing that has been happening a ton is people trying to back out of contracts under the loan contingency provision. So because of how frenzied the real estate market has been, and because of the volatility in the market, changes in interest rates, there's kind of just this general misconception that you can always get out of a real estate contract. And people say it all the time, and people generally, there's just, even people that aren't realtors or aren't in the real estate business, they think all you have to do is just send a termination notice and that's it. And the most frequent excuse is a loan contingency. And this is one of the few times where there are changes in the loan markets where it's possible that it's valid. But I see it over and over again where people make up excuses, and it ranges from houses that aren't really expensive to houses that are really, really expensive. It doesn't really matter who the players are. Everybody tries to, they'll use that as an excuse to be able to get out of a deal. And what you end up seeing on the lawyer side is not a really good explanation for why the loan terms aren't acceptable. The lawyer on the other side, or the person, will just say they're not acceptable because I said so. And when you start probing, there's no good answer. It's not tied to an interest rate. It's not tied in any way to the cost of the loan or mortgage insurance. It's not tied to the reasons that provision is there. And from the lawyer side, it's really obvious when somebody's lying. So I think that's it's almost better, if you want to get out of a deal, you just eat the earnest money and say that was a bad mistake, and you act in a way that's direct, and you just say, we can't close. Here's the reason why, and you back out of the deal, because in my experience, it tends to end up being more expensive to be able to fight over those problems than if you just own up to what's really going on.
That's a great point. And one of the things that I hear every once in a while is it's the brokers that are saying, oh, we can always just get out on the loan contingency, or we can get out on loan approval, or we can get on this. All we have to do is just check the box. And then they end up in the soup because they're telling the buyer, setting the buyer's expectations that they're going to get their money back when the seller challenges it later on.
Yeah.
I see that a lot. And brokers should be advising them that a contract's a contract, and the person that gets to decide is going to be the judge as to whether or not they acted in good faith or not, and how much money do you want to spend on it. I like your advice of, at least owning it and then going to the seller, and maybe they'll split it with you or give you something back or negotiate something instead of having to go through the brain damage of mediation in court to try and resolve it.
Yeah, you're able to get a much better resolution, in my experience, by being upfront. And when people come and say to me, "Can I get out of this contract because of the loan contingency?" The way that I explain it to them, I say, you know what? If you would go up on the stand in front of a judge and say that you opted out of the deal because of a loan-related issue, then that's totally fine. But can you do that? Like, no. But somebody told me that you can always get out of it with the loan contingency. So that's, and it doesn't matter whether it's for loan issues or anything else, but that's really the test. Is if you had to get on the stand in a courtroom, would you really say that? And that's
a great test. You know, you're going to get sworn in front of a judge and raise your hand and promise to tell the truth, and then say, "Oh yeah, it was really about the loan contingency. It wasn't about the other house down the street that I found that I thought was better."
No, not yeah. All right, and there are two other situations that have popped up recently.
Did you want to answer a couple of questions real quick?
Yeah,
Mark?
sure. Let me see.
Jill, you want to ask the questions?
I can read it if you'd like. Keith is asking, as a protection for a seller, Merc, do you recommend countering an offer where the buyer has waived all inspection rights with at least the inspection termination deadline?
I'm going to give you my answer regardless.
What do you think, Damian?
I like having the inspection right in there. I always tell, because what I'm always afraid of, Merc, and you tell me, I mean, you see a lot more of this than I do, but I'm always afraid that if it comes push to shove, you know, after the fact, the buyer finds something, accuses the seller, finds a plaintiff's lawyer willing to take some case that, you know, on a whim, and makes claims against the seller based on the fact that you didn't disclose and you made me waive my inspection in order to get this offer. And if you hadn't, and that was just part of the conspiracy to hide these adverse material facts. And if you had let me inspect it, I would have found it. You know, they get amnesia about why they waived it to begin with. And that's, I guess, if you had a paper trail showing it was initiated by the buyer, but they're just going to claim that the listing broker and seller told them, you want to get your offer accepted, you got to waive the inspection. I've always liked giving the buyer the right to inspect, and whether they do it or not, I could care less, but at least tell them, hey, you had a right. You could have inspected, you could have found this, but I don't know. What are your thoughts?
I totally agree. Because it's too big of a transaction. If you put yourself in the shoes of a judge trying to decide it, it's, for most people, it's the biggest transaction that they make in their life. And there's a lot of pressure, and a judge is probably going to look at it really practically and figure out a way to give somebody the benefit of the doubt. And it doesn't seem fair to anyone to have made that kind of purchase without being able to inspect. You don't buy a car without being able to inspect it. And so I think you're exactly right on that.
Thaddeus is asking, is there a limited amount of time before an accusation can be made against past sellers, like some kind of statute of limitations?
So the statute of limitations is 3 years, but it's 3 years from the date of discovery. So most of the time, once you're 3 years past the sale date, then you're probably okay. But if it's something that's a latent defect, one that you can't see, that can be pushed out a little bit farther.
A couple people asked about on the loan terms that it says sole subjective discretion. So why wouldn't they be able to get out of the loan based on that language?
Okay, so that's the next question actually answers it. So the next question is, does the good faith provision carry any weight? 100%. So that's the counterbalance to the sole subjective discretion, is that you have discretion to be able to opt out, but you have to do that in good faith. That's why I asked that question of, if you're on the stand, would you be able to look a judge in the eye and say, 100%, the only reason that I terminated the contract was because of the loan terms? Because the next question is, which loan terms were unacceptable and why? And in court, you're not going to be able to just say it was in my sole discretion. If you get to court, a judge is going to want to hear the answer why and probe farther. And if you don't have a real answer, you'll end up losing.
Yeah, I think there's a bunch of these now coming in on this, Merc, about the good faith and getting out. And I think that's an important point, is that sole subjective discretion, while it's sole subjective, if it turns out, I mean, I've seen where the lender's been like, well, they were fine with it originally, and then all of a sudden they change their mind. Or you have the broker who calls me that says, well, they want to get out on loan because they say that the interest rate is off, but there's a house down the road that they want to purchase. It's like, well, that's the bad faith, guys. That's it. And to Eric's question about brokers, and it's not really a question, it's a statement, brokers believe it's their job to get clients out of the contract. That's not true. It's not your job to get clients out of the contract. Your job is to advise them about their rights under the contract. So that includes, talking through all the problems that they could have of a bad faith challenge if they do something wrong. And Merc, I guess you probably see brokers getting in the suit because they gave the bad legal advice, even though technically they're allowed to give some of that.
That's we'll come back to the other on the other place where you find out that somebody's acting in bad faith is just waiting a month or 2 months and watching real property records. And that has happened a bunch of times too, where usually when a deal blows up, people want to react instantly and say, okay, I need my earnest money back right now. And sometimes they'll say, this feels like they were trying to get out of the deal to buy something else. Let's watch the real property records for 30 or 60 and 90 days and see what's really going on. And a lot of times there might be another closing in 14 days or 30 days. And you go, okay, here's what was going on.
Yeah, and it was the same price and the same terms and the same everything else. They bought a bigger house. So all of a sudden the loan was okay for the bigger one, wasn't for the little one.
So that happens. That's the other place that we talk about that you can go find great information. Somebody said one of the questions that was just asked is good faith applies just as equally to inspection termination, 100%. So whether it's appraisal, inspection, almost the good thing about the good faith provision in the contract is that it applies to just about everything in the contract.
Yeah, and the inspection is the one I hear brokers all the time. Don't worry if you don't like the property, don't worry, just put an offer in on the property. If we get to inspection, you just terminate then. It's like, well, changing your mind is not a contingency, and inspection doesn't give you the right to inspect it for whether you want to change your mind or not. So that doesn't really work. I mean, you really have to have a legitimate reason. And again, guys, you got to counsel your clients about their rights under the contract, not tell them how to get out. That's a big misunderstanding with brokers about, oh, my job is to get out. No, your job is to advise them about what the rights are under the rights and obligations are under the contract, just like a lawyer would, and let them decide what risks they're willing to take or not take.
Robin had a good follow-up question to that, where she said, so if we advise them that they could get in trouble for the lack of good faith and they still want to proceed, do we document the conversation and the warnings and then just do it anyway?
I think that, to me, that's a great idea because, and Damian had started to talk about this before, when there's a problem, the first place that people look is the brokers. And they do that because they know that brokers have insurance, and they think that because there's insurance, there's an easy settlement. And that's one of and it's not an easy settlement. And it's a really, the insurance companies don't pay unless somebody makes a mistake. And that's one of the second biggest misconceptions that people have is, I'm just gonna, and a lot of lawyers make this mistake, and I think to the detriment of their clients, that there's an insurance company on the other side, and if we go after the brokers, then they'll settle and win. And insurance companies are not in the business of paying those claims. And I'm talking to the wrong audience here. It's more, should be talking to lawyers saying, be really careful about bringing those suits, because you're not, the chances that what the clients hear from those lawyers and what actually happens usually end up being really, really different.
Yeah, along those lines, I hear brokers say, well, I made a mistake. Can I just call the E&O carrier and have them write a check so that they can pay my client because I feel bad? And it's like, no, they're not going to do that. They're going to want to defend the claim. They're going to want to. So, yeah, I regularly tell, well, Jim is my E&O defense, Merc. So regularly, okay, Jim, send a denial. Let's.
No, there's so much stuff on TV about how, especially on the personal injury side, how much people have collected and how they go after the insurance companies. In my experience, it doesn't happen on the real estate side with brokers.
Yeah, you better have some legitimate claims if you think you're going to settle something out.
Holly had a good follow-up question to this, and she said, so if a seller sues a buyer after they leave on loan terms and the buyer buys a different house immediately, what amount can they sue for? What are they suing for?
So usually it depends on how the contract is drafted, what boxes are checked. It could be, it could just be limited to earnest money. But the damages could also include earnest, if it's earnest money plus damages. That would be essentially the carrying costs of the house until it's sold. And so all of the expenses that you incur while the property's still on the market. So that could be mortgage, taxes, insurance, and maintenance related costs.
Yeah, just to make sure we're clear, our contract is by default, you get the earnest money and that is it. And then attorney fees and costs if you end up in that far along in the process. So Merc's talking about when they have a specific performance box checked, which doesn't happen very often. So make sure that you understand exactly the difference that he's talking about with those two.
Yeah. That's and depending on whether you're on the buyer or seller side, when people come to me and are asking for help on the acquisition of a property, that's one of the first things that we talk about. Here's how, if you end up in a dispute and you're on the seller side, you wanted, here's what you want. And if you end up in a dispute and you're on the buyer side, here's what you want. Next question, if there's a dispute regarding earnest money, can a buyer file lis pendens against the property to try and prevent a sale? And usually in that situation, it sometimes, but usually when there's a dispute over the earnest money, it's because somebody wants out of the contract. And so if it's the seller that is the seller that breached, then the buyer, if there's a specific performance obligation, can bring a suit for to force the sale. And if you bring a suit to force the sale, then you can record a lis pendens. If you just have a suit over money and it has nothing to do with title, then you can't record a lis pendens.
I think the important thing there too is that you have to have a lawsuit. You can't just record a lis pendens willy-nilly. Say, I'm a buyer, I'm going to record a lis pendens. You don't. This is a court action in order to get that lien against the property. This one's a fun one. You ready for this one, Bruce? Or sorry, Merc, it's coming from Bruce. It says, when the seller signs a CBS and then says after the fact they meant to do a counter, what are the consequences of them signing that offer? And what I see a lot on this one is they sign 4 of them because they accidentally signed 4 contracts and then, oh, whoops, that was by mistake. We wanted to sign 1.
This one is really tricky. I've dealt with it. So I was helping somebody in a dispute where the people on the other side came back after they had signed a counter and said, we totally made a mistake. And I remember thinking like that's ridiculous. Like the number of things that you have to do to be able to counter, there's no possible way that could have been a mistake. And I thought it was absurd. And then years later, it turned out their son and my son became friends. And they didn't remember that I had been on the other side. And they told me the story. It turned out to be true. And then I've talked to people and they're like, no, this happens all the time, that even though on the CTM form, it basically seems impossible that somebody could sign something they didn't mean to. It happens. It really does happen a lot. So that one's sort of like the way that the law goes. You think, oh, this is a slam dunk case. And the way that real life goes, they're totally different.
Yeah, would you talk about what the law is? Because I think it's important for brokers to understand this.
I mean, the law is the way that you would prepare a case like that as a lawyer is you walk people through the process. You would be walking a judge through the process that a seller goes through when they're accepting an offer. And it turns into a really long story when in real life it happened very quickly. But you would go to this box and then you signed your name and then you selected the font and then you checked a box, and then you went to the next page, and then you selected the font, and it becomes this massive deal, and it makes it look like you spent half an hour or 45 minutes signing the contract when you really didn't think about it at all. But the way that the law goes is when you sign, it doesn't matter whether it's electronic or it's by hand, whatever it is, you still sign and you're still bound to the contract. And the only real way that you can get out of that is if somebody tricked you. And even then, it's pretty difficult.
Yeah, so in other words, guys, protect your documents. Do not let your clients sign them. Do not send them the forms that are able for them to sign them. Put them in PDF, send it to them, and only after you know exactly what your client is going to do you send the link that they can sign. That's the best advice I can give you as far as protecting your clients, because guess who's going to get roped into that lawsuit when the seller gets sued for specific performance because they inadvertently signed a contract.
Yep. That's a really good point. One other situation that I've had that has come up for me 2 or 3 times recently, and that in both situations they were on pretty expensive houses. But what ended up happening is that the property gets listed, and the warning here is really when you're both situations that they're either with where you're representing somebody that's a friend or somebody that you've developed a close relationship with. But in both of these situations, there was a deal that was put together where the broker switched in the middle of the transaction and went from being switched into a transaction broker relationship. And Damian's shaking his head. And what ended up happening is that the deal gets started, the property doesn't get taken to market because of the kind of the frenzy that's going on. And what it feels like from my perspective is that the broker already had somebody lined up and then switches. And then after the fact, the person that sold is coming to me saying, I just, and in both cases, there's a high level of sophistication on all sides, but they go, I had trust in the broker, and there was somebody that I knew really well. They advised not to take to market, and then I went under contract and signed a deal for significantly less than what I think the property was worth based on other deals that were happening simultaneously. So that's, as for brokers, especially if you're going to switch in the middle of a transaction from switch into a transaction broker relationship, that's something where, and I think that the 2 lessons for me, if you're not going to take the property fully to market and be a transaction broker, that's something that is a pitfall and can have really significant financial consequences, especially on a house that's really valuable. And I'd run across multiple experiences with that, and the people at the end of the deal had to go through with the deal, but it left a really bad taste in their mouth. And I think the third lesson from that is a lot of business, just like in the legal world, a lot of the business that you generate in the broker world is all referrals. And you don't want people leaving the end of a transaction feeling like you didn't have their back.
No, that's a good point.
Then another thing that has come up a lot recently is people trying to undercut brokers in the holdover period. And it always is, people always seem to forget about the holdover period, but we've had multiple disputes in the last year where brokers introduced 2 parties. They were situations where there was a lot of work going into forming the relationships. The deal blows up, and then because the buyer and seller have each other's contact information or names, then they go and cut the brokers out of the deal.
And clients don't do that, Merc. Come on, nobody does that. That doesn't happen.
Oh, it happens all the time. And there's a roadmap for it. And that's the hard part about those kind of deals, is that you go, all right, you have a contract, it defines what the holdover period is. And when you go and record a deed, and the deed is recorded within the holdover period, that's not good.
That you say that one's not as hard to prove as the he said, she said.
That's one where you can usually multiply what you spend on legal fees pretty easily. So I think that's, but it's a good reminder of how important having the holdover period. You want to have it long enough that it's reasonable, but and long enough that it provides protection, but not so long that a judge would look at that and say it's outrageous. So 6 months can't really do that. 2 to 3 months is probably. Was that what you would think, Damian? Kind of 2 to 3 months is the outer limit on what's.
Yeah, I'm going to defer to you. I have no idea. I've seen people put them out 6 months, but I don't know what a judge would do with a holdover that is as long as the listing contract was, or even longer in some instances. But I think that's good advice that talk through that as far as what a judge might look at in those instances.
I think it really just depends on the fact how sophisticated the parties are. And if it feels overbearing and it feels like somebody was forced into a lengthy holdover period, then a judge will figure out a way to be able to get somebody out of it.
Oh, that's good advice.
All right, we've got a bunch of
we got all sorts of questions in chat and in Q&A, so I'm gonna let Jill kind of wrangle those so that you and I don't have to figure it out.
Okay, we'll just start from the top and work our way down. So Thaddeus had asked, are you seeing most buyers and sellers just skip paragraph 22 regarding mediation and just threaten to go to trial?
When I send a demand letter, every single time I make a demand for mediation to comply with that provision. Practically for me, most of the time, it's not that helpful to mediate on the front end until you have everybody has full information. So a lot of times we'll skip it, but it's really because it's more helpful for the process to wait.
Would you talk about what happens when you're in the process too? Because don't most judges require it later anyways? Yes,
once you're into litigation, mediation is almost always required. So it's really just pushing. And so if you're because you don't have complete information, so something like a loan contingent, someone says, I'm terminating for a loan contingency. If you go into a mediation without pre-lawsuit and without any kind of backup, all that's going to happen at the mediation is they're going to say the exact same thing they were saying before, and you don't have any backup to or any kind of due diligence to be able to figure out whether they're really telling the truth or whether it's pretext for something else. So deferring the mediation until later is helpful. The other situations where you have all the information that you need, and having an early mediation is really helpful if you can't just get a deal done. All right.
Okay. Lisa asked, if a buyer terminates based on inspection or loan terms, does the seller have the right to ask specifically why they are terminating? I don't see a section in the terms that would allow the seller to really press for a specific reason.
They don't have an obligation to tell you why. You can always ask, and a lot of times it's helpful to ask, just to call afterwards, as for a broker to call the other side afterwards and say, can you give me some feedback on what really happened? And they may not give you any feedback, but it's definitely worth asking, especially when it doesn't feel right. Because when something doesn't feel right, most of the time it isn't. And you've got a deal that's going along great and you haven't heard anything about loan contingency, and then all of a sudden it pops up and becomes the basis for termination. In a situation like that, it's really helpful to try and figure out what happened. Yeah, the other thing, Merc, just because you can ask and they may not tell you, let's say that the seller says, hey, I kind of question what's going on. And then, like you said, they look at the public records later on and see that they bought a house 14 days later that for the same price or higher or whatever the case may be. They will have to explain it to the judge at that point, right? I mean, yeah, that's exactly right. So it's not like, the buyer can just say, oh, I'm never telling you. If the seller pushes it, the judge is going to ask. Yeah. Yeah, that's the one thing about once you go to trial, all the nonsense that happens during the course of a deal, where all the bluffing, for the most part, it all goes away. You get to the core of what really happened.
This is an interesting one. This person says recently had a case where the wrong contract was signed, and it seemed to matter how quickly the mistake was pointed out. In this case, the seller within 15 minutes said, "We signed the wrong contract." An attorney said there was no meeting of the minds and the contract was void. Does it matter how quickly you point out that a mistake was made?
I can't wait to hear your answer on this one, Merc.
I think it's something that a judge would definitely take into account, that the closer in time that the person said they made a mistake, the more likely that it's true. If it was 48 hours later, especially if it's a buyer and you know that they're out looking for houses, if it's 48 hours later, then you go, oh, you really meant to terminate and it said you accepted? Like that doesn't make sense.
Well, and the other thing is that's an attorney making a claim for a seller. I mean, he says he had a recent case. I bet you that was not litigated. Well,
Yeah.
Don't you think that's an attorney that represents the seller that says there's no meeting of the minds and coming up with legal arguments to fight over whether or not there was one? And
Yeah.
frankly, if I was representing the seller, I'd make the same legal argument in hopes that I could scare the buyer off, and not have Merc come in and say, well, wait a minute, you still signed it. It's still agreement. It's still, because it would have been interesting if that had gone further than one attorney saying, oh, it's no meeting of the minds. Don't you think, Merc?
Yeah, and it really depends. I've had a case that went all the way through trial where there legitimately was no meeting of the minds, but it was a case where there were no brokers involved, and people were using a form contract that they had pulled off the internet that was at that time it was 4 or 5 years old, and then they were amending it with an amend extend form that was just a few years old. And then there was all kinds of wild stuff that had happened in between. That one, there truly was no meeting of the minds. It was people were still signing by hand and faxing the signatures back and forth. But whether there's a meeting of the minds it's a really expensive question to figure out, and not one you want going to trial.
Keith had a follow-up question regarding the holdover discussion. Is there any situation where a judge would rule in favor of a broker if they had not submitted a written list to the buyer or seller while the listing contract was still active?
That's
The only one I can think of is if they submitted a contract. I think that still would count as a written prospect list. If you had submitted a contract with that buyer's name on it and they didn't accept it, and then don't you think that would be strong enough to say that's a written submission?
yeah, that would definitely be. And that, yeah, I think there's just so many different ways that could be. But a contract for sure, that definitely gets. That's probably the best example.
What about emails? I mean, maybe that's what he's getting to. You don't have to have an actual list as long as you submit it in writing, I guess.
Yeah.
Keith likes to ask the difficult questions.
Every time. Okay, Dirk asked, there's this one last question in Q&A, and then we'll go over to chat. If one of the brokers has not signed the purchase contract, is the contract fully executed?
That's what the judge really will care about is the buyer and seller. And if it's not signed by a broker, that might impact a commission issue, but wouldn't impact a dispute between the buyer and seller.
Yeah, that's when the upset person that didn't want the contract to be fully executed is going to blame the broker for not signing it and file a real estate commission complaint. It's because they didn't do their job.
Yeah.
Okay, rolling over to chat. Chad had asked a question earlier, I think about getting out of the contract. Can't a buyer just be super tough on the inspection, which typically leads to a termination?
Of course.
Yep.
Okay. Tara said, we have one that a seller who listed the home as an estate of a person in a conservatorship sent over a counter and the seller executed the contract as the conservator. Buyer signed, and then the listing agent said, wait a minute, this needs court approval. Can you enlighten us on something like this? Is the contract potentially invalid?
It probably does. That's a tough question because it would depend on how the conservatorship is set up. But most likely, if you're almost there, but you still would need court approval in order to make it effective. That's one I haven't come up with, but that's that I haven't had to deal with before. But you could have a really weird situation where a child ends up inheriting property and because their parents die and they can't hold title to property. And so you have to have court approval to be able to sell it. Same thing if somebody was incapacitated.
Yeah, and even some probates that might have judicial oversight or something, contested probates might have something like that too. So yeah, it probably has to have approval. I mean, that judge is going to have to approve it, which means who do you enforce the contract against?
Eric asks, how often do you see cases where the broker speaks for their client, blows up the deal, and when that is the client actually wanted?
I see it with lawyers all the time. So you'll send a settlement proposal and the lawyer will respond in 2 or 3 minutes, and you go, there literally is no way that you talked to your client and found out what was going on. So if lawyers are doing it, brokers are doing it. It's not
well, we all know best. We know best, Merc. Come on. Why would we want to get the pesky client involved in these things?
That would be a great question to ask. How often do you see a case where the lawyer blows up the deal? We should ask that one.
I bet you these guys have opinions on that.
Oh, that's the fodder for a good lawyer joke.
Okay. This is kind of going back to accidental signatures on contracts. So what happens if the CBS is accidentally signed by the seller? What happens if the seller pulls the house off the market or refuses to sell? I'm working as a buyer's agent in this scenario.
Okay, so that's part of the answer to that is really a good faith question, and it's hard to and somebody had pointed this out. There's actually a pop-up box that says, "Are you sure that you want to counter? Are you sure you want to sign this deal?" And even though the electronic system is set up so that it's almost impossible to accidentally sign something, it happens all the time. And so really, like, this comes back to the same thing on, do you blow up a deal over loan contingency? If somebody, a big part of your business, it's the same thing in my business. A big part of it is being able to trust people on the other side. And so you have to, if someone says they accidentally signed it, you kind of have to go with your gut. You go, all right, 50% of the time, that's probably true. It's bad for the brokers, but you don't want to, the advice that I give people a lot is sometimes that accidental signature may be the best thing that ever happened to you, because then they don't take your deal and then you don't end up buying the house and you never find out what it was. But there's a lot of karma that goes into how things work. And so sometimes I try and say, oh, hold on, is that, I know this house is special, but maybe that was somebody looking out for you and you just want to let this one go. And then sometimes it's just an outright lie. And you guys have a much better sense of that based on what's happening in conversations. And if you get an immediate call that's, oh my gosh, I just heard from my client and they pressed the wrong button, that's one where you go, okay, it's probably probably true.
I will tell you, in 2021, we saw a lot of people that accidentally signed contracts. So, and then you had buyers that really wanted to enforce contracts because there was nothing they could buy. So I'm going to tell you, obviously Merc's going to talk about the legal implications and what advice he might give to a client. For you guys, you represent the buyer. I would tell the buyer, look, this has legal implications. If you want to enforce this, it could be expensive and time consuming, but you might have a right to enforce it, but you're going to need to talk to a lawyer and make sure that they understand that's the next step in that process, regardless of whether the seller pulled it off the market or didn't. That's, the question is, how far do you want to push the seller to force them to sell? And if you're on the other side representing the seller, you might point out to them that, the contract is specific performance for sellers every single time, regardless, which means if Merc comes in and says, well, I believe the seller meant to sign this and then change their mind, we're going to enforce this and we're going to take it to court. Then number one, they're going to file lis pendens, which is going to tie the property up. Number two, they're going to file for damages and specific performance. And by the end of it, it could cost the seller a whole lot of money for trying to play possum by taking it off the market. So, you guys just got to warn them that there's a lot of legal risk on both sides of that equation, and they have to decide whether they want to take that risk or not.
Is that because people have been cooped up at home and been drinking too much?
It's because of the low inventory, Merc.
Oh, I'm
Be a little bit of both.
wait until after a few drinks to figure out if I'm going to sign the contract or not.
Yeah, I hear people make their best decisions after drinking. I saw you laughing at the 1 out of 3 deals get blown up in New York by attorneys. I know that's what you were laughing at.
Oh yeah, that's for sure. Might be the same in Colorado. That's one of the great things about not having attorneys involved in every deal in Colorado.
Yeah,
Joe, you keep a lot of deals from getting blown up.
Right.
Yeah, you want us to over lawyer it? Just let us get involved. It'll be great. Honey, you got any more?
Yeah, we're at the hour. Merc, if you had anything else you wanted to mention, you can, or we can wrap up. We want to be respectful of your time.
Okay. No, I had just to me, some of the best advice to me that people are, even if you're a realtor and you're buying a house, you get caught up in the moment and the emotion of it. And as a broker, I think one of the most important things, I feel the same thing when I'm working with clients, is that you trust your gut. And I can't emphasize that enough, that if something really doesn't feel right, it probably isn't. And if something doesn't feel right to you, that's the time to be able to try and put the brakes on transactions and say, hold on, something just, it doesn't add up. And sometimes it's things like mineral rights or water rights or a well. Sometimes it's something about where a fence is located. It could be something about that you hear in a condominium about lawsuits that the condo's been involved in, or it could be development that's happening in the area. But there are all kinds of different things that clients expect you to be their eyes and ears, and it's really important to trust the little things. And when something seems out of place, that's the time to dig deeper. And that's really where you can provide great value to your clients and have them come back to you in the future, because you did something that helped save them from a big problem.
That's good advice.
Thank you, Jill and Damian. Thank you for having me. This is a lot of fun. I hope it's helpful for everybody.
Incredibly helpful. Thank you,
Merc. The
Merc.
comments come in, Merc. Apparently they like you, which I don't get. Whatever.
Merc's always a favorite, for sure.
Thanks for your time, Merc. It was fantastic, as always.
Thank you, guys. This is great.
Absolutely terrific. Thank you, Merc. Thanks everyone for joining us, and we'll look forward to seeing you next month.
All right. Bye-bye.
Bye.
All right. Bye-bye.